Good afternoon, my name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to provide you with some updates regarding immigration court proposed changes that may come reality and new policy regarding the processing of immigration court cases. So first of all, let's start with the proposed rules that will significantly change one's ability to present a defense in immigration court and or reopen their removal order. There are two proposed rules. One affects motions to reopen and one affects definition of good cause necessary to show when a person asks to continue or to adjourn, to postpone their immigration hearings, their immigration case. So let's start with motions to reopen proposed rules. The rule proposes basically to severely restrict one's ability to reopen their immigration court case. First of all, it contains direct prohibition on reopening if there was a finding of frivolous asylum filing in the past. So if there was a finding of frivolous asylum filing in the past, does not matter now what you may qualify for, or it will not matter if the rule goes into effect. A person will be prohibited from filing a motion to reopen. The rule further emphasizes that a person may file only one motion to reopen, only one. Well, it's always been the case, but then they're very strict and they specify the conditions under which there is this exception as to when person may file more than one motion to reopen related to country conditions changes in connection with asylum filings, right? So the new rule basically says it's going to be not for granted that you will be allowed to reopen your case if your country conditions changed. You will have to show that the change is material, you acted promptly and things like that. It's kind of something that we've been doing before, but for some reason this rule gives bad taste in my mouth, okay? Because it has some other interesting provisions. For example, it says that if a person departed the United States while the motion to reopen was pending, it equals that the person abandoned the motion, withdrew the motion, and the motion will be denied. Okay, so departure now means a denial. Very important. Another very important addition. Now, not now because it's a proposed rule, but when the rule is going into effect, the person will have to show, will have to explain if they received a notification to surrender from ICE after they received order of removal and what they have done. If they requested an administrative stay of removal or they just ignored the notification of surrender. Very important change if it's going to go into effect. So basically, it will be much harder to qualify for a motion to reopen. You will have to show additional qualifications for it in addition to what we have now. I'm not sure if it's actually going to go into effect. I think if new administration comes in, that rule is going to be scratched off. All right, I hope so. Then we have one more rule regarding good cause necessary to adjourn cases or ask for more time when you need more time in court. Why would you do that? Like, what's happening? Well, consider this. You come to court by yourself, you don't have a lawyer, and you say, Judge, I need more time to find an attorney. Is the judge going to give you more time, or something else is going to happen? Is the judge going to force you to represent yourself, basically? Well, currently, the judge will give you more time, especially if you come like this for the first time. But this new rule says that it's not going to be automatic. The judge is going to look at how much time you had, this and that, and generally is going to be giving you very short adjournments, like 30 days. If, let's say, you had a lawyer and the lawyer didn't show up, your hearing is going to be postponed only for 14 days, okay? The good cause rule, as I call it, also says that to qualify for any type of adjournment, you will have to show that you have a particular and justifiable need for it. All right, so it's not going to be just saying, so easy just to say, you know, Judge, I'm waiting for USCIS to grant my U visa petition. Can you give me more time? You'll have to spell out your reasons in a brief and explain why it's not going to negatively impact the immigration court proceedings timelines. Hopefully the government is not going to oppose your request, because now the judge is going to look if there is an opposition and what are the arguments for it. The judge is going to look at how much time you had to prepare for your applications, if you need more time to file your applications. So it's, you know, basically everything is going in the direction of not giving you much time and forcing you to act fast. All right, so that's what's going on with those two proposed rules. Again, they're just proposals currently. If the new administration is going to come in, I envision that these rules probably not going to be adopted in the current version of explanations as to why this good cause rule needed to be changed. And they're basically priming you for pages, and then they give you the draft of the proposed rule where you read it and it's like, wow, now nothing is going to qualify for good cause, short of you marrying your boyfriend or girlfriend of several years. You have a super strong case, maybe a couple of children now, and the boyfriend or girlfriend is a US citizen. All right, the rest of it is basically just going to be too difficult to win. Those are the proposed changes. But there is one thing that was adopted, and it's not proposed change, that you must know about, especially if you're in removal proceedings or you have a potential of being in removal proceedings, which is like everyone without a green card or citizenship in the United States. Very, very important. From December 1st of this year, the court is going to change the way it processes master hearings and the way it conducts its business. From December 1st of this year, if your attorney files his or her notice of appearance at least 15 days before your master hearing, that hearing is going to be vacated. It's not going to take place. But the judge is going to send to your lawyer necessary notifications under the law, like a notification about fingerprints, timeliness, and schedule as to when you're supposed to file various applications for reliefs and present your pleadings. Very important. So far, people started receiving these scheduling orders, reported that they have very short deadlines. This new policy says that you're going to have usually 45 days. But check this out. If they send this notice to you by mail, you're going to lose about a week. So it's going to be much shorter. Let's say be prepared within 30 days with your attorney to prepare your entire submission, okay, to prepare your entire submission, or most of it, and to answer the pleadings. Sometimes the problem is that sometimes it's not as easy. Sometimes you need time to request freedom to file and receive Freedom of Information Act request, so it's going to be tough. What's going to happen after your lawyer submits, hopefully and meets this deadline, that the judge again is going to schedule the next step. Instead of meeting with everybody, the judge is going to schedule next step of individual hearing, and when you're supposed to file either motions or maybe oppositions to motions and maybe some additional evidence. So a lot of the processing of paperwork is going to be done via paper like that, okay? And this new policy also emphasizes the need to discuss the cases with the prosecutor, to basically follow the judge's scheduling order, do everything very fast. And how are you going to do it if you don't have a lawyer? It's going to be very, very tough, okay? It's going to be very tough. And this, what I'm talking about right now, is already in effect, okay? That they're going to vacate the hearing if the lawyer files notice of appearance earlier than 15 days before the hearing. If the attorney does not file her notice of appearance within these 2 weeks, but does it on the day of the hearing or right before the hearing is going to take place. But there is a paragraph in that motion saying that if there is any type of misrepresentation regarding availability of an attorney, you can be punished. Okay, so if you're intentionally trying to give yourself more time, you can be punished for it. It says there in that new policy. So everything is designed now to be very fast, right? And on paper, so you don't have to see anyone. Can come with some negative consequences in many cases, unfortunately. All right, so these updates for immigration court for this week. One thing you need to remember, that you have to work with your lawyer and bug your lawyer about those deadlines, that the lawyer checks that mailbox to make sure that he or she does not miss that scheduling order, because if the scheduling order is missed, you will not have time to produce quality work, and any quality work, any quality preparation requires time. Well, thank you very much, guys, for watching. Please subscribe to my channel if you haven't done so. I'm sharing on my channel various updates, provide tips regarding immigration situations. Please like, share this video, and I hope to see you soon.